Good morning, everyone. Welcome to the meeting of the Baltimore City Senate delegation. I'm Senator Mary Washington, honored to be the chair of our delegation this year. For the last 2 years this year. So I'm going to call us to order. We're going to begin by talking about, that next Friday, just some business. Next Friday, Senator Antonio Hayes will take the chair as I won't be available for our next set of hearings. And we're also, the comptroller, I wanted to ask folks, the comptroller is interested in meeting with us. So if you could get back with me about a time that you think would be good for that, or maybe Senator Hayes, you can work with Elijah on that in the coming weeks. We did.
Madam Chair,
Yes.
which comptroller might you be referring to?
Oh, I'm sorry. The state comptroller.
Okay, great. Thank you.
The Maryland State, our Maryland State comptroller.
Hey, girl. How are you?
Who's on iPhone? This person was, whose iPhone, if I could ask?
Yolanda?
Oh, okay, great.
Yolanda Winkle, I'm sorry. I need to mute. I apologize.
Yeah, no worries. No worries. Welcome aboard. Also wanted to let all of you know that we did send a letter on behalf of the delegation to the acting secretary of MDOT to really push for funding of our Be More Plus plan for the FY27 budget. This coming Monday, we will have a bill hearing and voting session on Monday. We really want to make sure we get things done. And so are there any comments or questions at this point? Okay, I'll officially call us to order. We're going to have, we are honored today to have a briefing from our Baltimore City State's Attorney, Ivan Bates. Give us a brief. We've got a lot of voting, but we know you're dealing with a lot of very important things. And in fact, I read in the paper today, there's been the result of a bus of quite a number. So if you can tell us a bit about that and the public about that, and then we'll open up for questions, maybe about 5 or 10 minutes, which we could spend more time, but we have a really robust agenda this morning. Oh, it'll be good. Unmute yourself.
Sorry about that. First of all, I want to say good morning, Madam Chair, and good morning to the delegation, everybody. I'm not only coming as the state's attorney for Baltimore City, I'm also currently the elected president for MSA, Maryland State's Attorneys Association. I'd like to touch base first with a couple of our priority bills, the state's attorney's office. Our number one priority bill is House Bill 3.
Sorry, I'm sorry, Mr. Bates, if you could just start with kind of the agenda we set forward, and we're definitely interested in hearing about that. I'm sorry if that wasn't conveyed, but if you just start with kind of what's going on with your office, what's to us, as Baltimore City representative, and then if we have time, we certainly are aware of the priorities, and we can ask you maybe during the discussion period we can handle.
Okay, all right.
And really, congratulations on being the leader.
Thank you. I mean, look. From Baltimore City State's Attorney's Office, we really feel that we're in a really good place, a good space. Recently, like you acknowledged, we recently worked with a lot of our federal partners, even BPD. We had not even a bust. We basically looked at a number of open warrants from the federal side, working with ATF, DEA, led by the U.S. Attorney's Office. We took about 200 violent offenders off the streets, did a number of drug cases, a number of cases involving guns. These individuals will now be prosecuted federally. This was about a 2.5 to 3 week work in progress. We worked to prepare this for about a month, 2 months, working with all our federal partners. Without a doubt, the federal and the local partnership, we feel really is making a change in the work that we've been able to do, along with everybody that's in the community doing the work as well. So we feel very good about where we are. Just in terms of as an office, we're now almost up to 200 lawyers. When I came in, it was 140. So we've trained a lot. We feel that we're working in a good place, a good space. We're working with our community partners and things like that. And overall, when you just look at where we've come from as an office, we feel right now our priorities in the juvenile system. We put together a 100-page juvenile booklet to allow everybody to understand the state of the juvenile system. I do understand, one of the major issues coming out now in Annapolis will look at Senator Smith's bill, looking at automatic charging and things like that. However, we just feel as an office, if that bill does go through, that we're going to definitely need a lot more resources. We're going to need to hire more prosecutors. There's a lot more clerks, things like that. But we're just pretty much saying that right now, in reference to that bill, we just have a system that we can't give anything else to.
That's great.
Mhm.
And so do you have other people on your team here? Perhaps you could introduce and then we'll take questions. And as I said, during the course of our conversation, we can certainly talk about if the body wishes to, pending legislation.
I know I have Hassan Giordano here. He's on my team as I think also, if I'm not mistaken, we had, I guess Yolanda was here, but Hassan Giordano's with the community outreach, the things that we've been able to do, the things that we've been able to accomplish. Like, once again, the biggest thing is the growth of the office has really been able to do, working with all our community partners. We had a great year last year in terms of what's happening in the community. Without a doubt, working collaboratively, the murder rate was down to 133. And so we've been able to be successful in that regard. We just are very happy where we are, where we're headed, and we just want to continue to stay the course, working collaboratively with everyone.
I definitely want to tell you that on behalf of our delegation, but also as a Baltimore City resident, absolutely appreciate the work that's being done and the joint efforts to reduce the murder rate. Would love to hear more about the sort of proactive community-based initiatives that you're doing, but I'll let Senator Hayes ask his question. Oh, I thought you looked like you were asking a question.
No, sorry, I didn't.
Or
No, I
comment.
apologize.
You have one of those faces. Okay. Do any members have any questions or want to follow up on anything that was said? No, am I the only? Oh, well, okay. Well, tell us about the bills then.
Well, one of the main bills is the bill that Delegate Jackie Addison has, and I believe also is cross-filed, if I'm not mistaken, by Senator Sidnor. It's the bill in the state on the House side is 336. This district court commissioners bill, and once again, local delegate from Baltimore City, Jackie Addison. And pretty much what it says is that looking at the district court commissioners, they've had a wide power to issue arrest warrants. We're saying let's just go ahead and stop that, because sometimes when arrest warrants are issued, they're issued for the wrong individual. Sometime by the time we do the research, find out. We just want to make sure that now when an individual has a issue or a problem, for instance, they can go down there and say, someone shot at me. Okay, then normally the commissioner would just issue an arrest warrant. Now that individual comes to the commissioner, they would still make that complaint. We would investigate it hopefully within 72 hours, say whether or not the police should, hey, this is an arrest warrant, this is a summons, this is a subpoena. We're even working with the domestic violence community to try to say, with domestic violence cases, the court commissioner may issue a summons for those complaints, not an arrest warrant, but a summons, and our office would have 72 hours to investigate to say, hey, is this a summons or is this an arrest warrant? This issue was brought about by a story that the Baltimore Banner had done, but were already looking at that. The rapper T.I. is kind of what we call the bill in our office, because the rapper T.I. was accused of having done sexual assault, if I'm not mistaken, on an individual, never knew this individual, but there were arrest warrants for him. That's one of our main issues.
Just there, because you're packing a lot in and I know one of the things I wanted to ask is you mentioned that your office, just coming into office, that you're taking a different approach, and you also mentioned about how there's sort of some errors in arrest warrants. I know that has been an issue about the quality of the data, and are there things that we can do as a legislature, or that the city can do, or what can we do to, one, understand the nature of those problems, but also get the proper, making sure that we fix it and that we have the right information in order to take action?
Well, the biggest thing, and look, the Baltimore Banner wrote a phenomenal piece that kind of breaks everything down.
Okay,
What
well,
you
can you
have,
just tell us? Yeah, thanks.
yes, yeah, I was going to say. And so what you have is that you have a system that sometimes people misuse. Sometimes people are angry, therefore an individual's incarcerated, they're locked up. And it's difficult for us to prove sometimes that this person is lying, where they could honestly make a mistake. We just want to say, when an individual goes to the commissioner, if they're going to take out charges, that the state's attorney's office should be involved so we can at least see, is this a viable case? And if it is a viable case, we want to make sure that we're able to talk with the police to get the evidence needed to prove the case beyond a reasonable doubt. Sometime an individual may have a viable case, go to a clerk, the commissioner, and there's information evidence that won't come to our office, that by the time we get the case, the information evidence could be destroyed. And, that to us is a very important issue.
Well, I guess we'll raise this in the hearing, but I'm raising it. We're considering a bill about getting access to juvenile records. And there's a number of issues across the state where we're contemplating the use of data. I was really speaking more specifically about errors that the database that you're using, that you've got the right information. I understand there's just some, not whether or not you can charge or collect that, but the information that's actually entered into the system, or the name that's presented, or the address, or the charges, that there are errors there. Is that anything that has impacted your agency? And if not, I'll just move on.
No, it really isn't.
Right.
Our issue is just different in the sense that people go to the commissioner and they're making claims. We just need to be able to investigate those claims before we arrest an individual. That's all.
That's great. It's great. Okay, we have a little more time. Any senators have any questions, comments, curiosities? Okay. All right, then. Well, thank you so much for your time.
Thank you.
And we'll definitely keep doing the good work. And we'll get started with our discussion of our voting session. Right.
No, thank you very much.
Thank you. And we'll talk again.
Okay.
And thank you so much, Hassan. You've done great work over the years. Another 43rd District, a resident there. Okay, so we will start we're going to discuss the SB 90. This is by request of the city. Senator McQuay, do you want to remind us of it, or should we have
290.
290. Yeah, SB 290. Yeah.
You can let the city.
Okay, so Nina, can remind us what that is?
Yes, Madam Chair. So Nina Themelis, Baltimore City, SB 290, and I apologize for being off camera. I'm having some issues with my computer this morning. But SB 290, the way that it was introduced, would have made changes to the express powers provided by the state to the city regarding the maximum amounts that the city is able to charge for certain penalties and fines. And so the bill as drafted would have increased that amount from $1,000, which is a cap set in 1983, to $5,000. The amendment that you all should have before you would instead provide the local jurisdiction, so would provide Baltimore City with the ability to determine what that maximum amount would be. Okay,
I see. The members, I have the amendment. It should be amendment number 123-7261 / 1. So any discussion on the amendment or the bill as a whole? So
The amendment should have put it in the posture in which it was voted out. Last time.
yeah. So is there a motion?
Sure. Move favorable with amendment on Senate Bill 290.
Yeah. A second?
Second. Thank you.
Okay, so we'll pass the amendment by unanimous consent there. So on the bill, any discussion? Okay, any readiness? Okay. All those in favor of Senate Bill 290, say aye.
Aye.
Okay, you have your hand up, Senator?
No, that was I.
That's your
That
eye?
was- yeah.
Okay, great. Well, thank you. All right, then we'll send a letter to the committee. Next is Senate Bill 279. Haley, could you remind us what the bill is, and then we will discuss and vote? Or Senator Hayes can do it.
Sure. Yeah, Senate Bill 279, Baltimore City cigarettes, other tobacco products, and electronic smoking devices, local laws authorization. Up until 2013, the city of Baltimore had the authority to legislate around tobacco products. There was a court case in Prince George's that had an effect on that that said, unless the state affirmatively state that this is something that the locals could legislate on, the authority rests with state government. And so this bill gives express consent to the city of Baltimore to legislate around tobacco related products. There is an amendment which I circulated to everyone earlier today in a reprint. That amendment is as a result of some testimony, written testimony that you also should have from the city of Baltimore. If you guys remember, a couple of years ago, we gave the city of Baltimore the authority to enforce loose cigarettes. And so this amendment just is making sure that the bill is consistent and that the city will maintain that authority. Any questions?
Okay, motion on the amendment.
Yeah. Madam Chair, I move that we move favorable on Senate Bill 279 with the amendment.
There we go. All those in favor? Oh, a second?
Second.
Thank you, Senator Tar.
Thank you. All those in favor?
Aye.
Aye, yes, all righty, great. All right, now, thank you. On to bill hearings. We have Senate Bill 524. Nina Themelis will discuss this. I know there'll be some discussion. We have three witnesses. We have Nina, we have Stephanie Mavrodis, who is the director of the mayor of Muncie. And also we have on standby for any questions, Jeff Halsletter, General Division Counsel for Baltimore City Law Department, and there may be some other representatives. Okay, so Nina, are you first, or will it be Stephanie?
Given that I'm having difficulty with my my computer this morning, I'm going to defer to Stephanie since she is on camera, and Jeff and I will be providing support for answering any questions.
Great, thank you.
Not a problem. Good morning, everyone. Stephanie Mavronis, Director at the Mayor's Office of Neighborhood Safety and Engagement. Can talk a little bit about Senate Bill 524, which we had the hearing yesterday afternoon. This bill, at its core, restores a carve-out that had existed in state law for a little over a decade, that allowed limited access to certain juvenile police records if and only if my agency is providing services to that young person. This legislation, as stated in Senate Bill 524, also adds two other agencies that provide direct services, be it mentorship, some form of case management to young people, the Mayor's Office of Children and Family Success, and the Baltimore City Mayor's Office of African American Male Engagement. And again, the requirement is that we're working with that young person, creating a comprehensive treatment plan. For us, this is about making sure that the same way we've found really effective in our group violence reduction strategy, when we have all of the facts at hand, when we're working with young people to develop a comprehensive treatment plan, we have the full context, we're working with that young person and their family, that this is something that allows us to do our job even more effectively, and our agency partners, the police department, Department of Juvenile Services, both agencies that we're in the process right now of enacting a memorandum of understanding around. They all want to make sure that we can continue to effectively coordinate and share essential information while making sure the data of our young people is as protected as it should be. I think that's the core of this legislation, but again, very happy to answer any questions and dig in a little further.
Okay, thank you. Anyone else testifying? Oh, sorry, my camera. Hold on for a second. I'm having trouble with my camera, so I'm gonna take that off. Any questions?
Madam Chair.
Yes, please go.
Hey, good morning. Stephanie, from my understanding, did the city have access to this already?
So since, yes, except for since October 1st on, the carve out expired. And so it wasn't clear in the way that this was originally pushed through. This dated back to the time of Mayor's Office of Criminal Justice. So since that point in time, for example, one of the ways I've seen this work in our case when the carve out was still in place was that when we were referred a young person for some kind of connection to services, the Baltimore Police Department was permitted to share that young person's police incident report with us so we could better understand what led to them being, diverted to us in that case. Now, with the carve out having expired, the police department doesn't have a legal mechanism to share that report with us. So we'd be relying fully on, the voluntary disclosure of what that young person or family might be saying. We'd be taking folks' word for it. I think, we all want to be able to continue to share as we have been, but right now, this carve out was giving us the legal permission to share across agencies in that way.
Right. And so the point that I was trying to establish is what this isn't something new. You guys have had this access before.
Correct.
It expired, and I don't know how long you had it. How many years did you have it before until it expired?
What I've, from our research, and I know we dug into this with the law department a little bit, it appears it's been on the books for more than a decade up
Okay.
until, and it looked like it had been extended, for whatever reason, it was time bound. So like it was in there for a couple years at a time. And then someone, typically, I think it was in the past, a staff person at Department of Juvenile Services was kind of putting in the mechanism to extend them. We just ended up figuring out that this one had expired on the 30th. And so now what we're doing is trying to put it back in, of course. The only change, Senator, that I'll flag is that this language does also include the other two agencies that I mentioned, so not just limited to MONSE.
What are the other two agencies?
Mayor's Office of Children and Family Success, which provides intensive case management services with the interagency group. We're a part of that group as well, to families that have been and children impacted by violence. And then Mayor's Office of African American Male Engagement, which has, cohort models, provides mentorship, life coaching for some of the young people they work with too in their age range.
Gotcha. And lastly, I see my colleague Senator McCray have his hand raised, but you all have systems in place to make sure that there's not misuse of information as it relates to juveniles and stuff like that, I would imagine.
Absolutely. So we use a secure case management system. It's the same system that we use for our, highly protected GVRS data. It's the same case management system that we use for data across our programs. Within that system, each of our different programs is privacy protected. So only the staff that are working on that specific program have the ability to access those records. So for what we're talking about here with the juvenile records, only the two staff people on my team that work with youth opportunity cases would be able to access that data in addition to agency leadership. But it's, highly protected and bound by the same language that's in this overall statute that we're seeking to amend. So that also governs our responsibilities with the data, after our programs have concluded.
Thank you, and thank you, Madam Chair.
Senator McCray? Senator McCray, did you have your hand up? And again, I apologize, my camera is on the fritz.
McCray, you're on mute if you're talking.
I lost my connection is what it was.
Yeah, something's going on.
We can hear you now.
Now we
All
can.
right. Yeah, I was just saying, I don't believe that I've ever voted on any type of legislation from this point. And let me be clear, I do think that the intent is very meaningful from that standpoint. I just had one question, like, do you get the parental signature or the guardian signature when you receive these records? Like, is there something documented that the adult in the relationship with the child, the juvenile, that you have their permission?
Yes. So, well, this all is part of the intake process. So when we sit down, let's say a young person's referred to us from the Baltimore Police Department, or as we move forward, we're going to see more of these cases being referred to us from DJS. If a case is referred to us from DJS, of course, we have the information about that young person, but we can't speak to them alone. So we're sitting down with the young person, and their parent or guardian, and completing the intake paperwork, which does include, disclosures, signatures, the essentially enrollment into the program and work that we're going to do together. And then as a part of that intake process, that's when the record would be furnished from either the police department or the Department of Juvenile Services at our request. And we would be requesting these, of course, on a case by case basis.
Other questions? I think I want to follow up on the data piece, if you don't mind. Sort of the question that I raised with regard to the quality of the data, where it's actually collected from. I know we had a bill a couple of years ago about the data hub. I know that the Senator Tar was the sponsor. Is this related to, is that this data?
I'm not sure. I guess just if I describe this data, and Jeff, feel free to jump in because you may know about some of the other things that were referenced. This data, so in my case, because of the type of agency that we are, the type of programming that we have, we're typically working with a young person in a pre-adjudication phase. So I haven't connected with a lot of court records, for example. Typically in our past work, it's really been about that connection with the police department, being able to get that BPD incident report for the matter at hand. That's important not only for us to have the facts of the case as documented by the police department or whoever engaged with that young person and wrote the incident report, but it's also very important because it includes, let's say we have the case of a commercial shoplifting case, and a young person is going to be diverted to us for that reason. In that case, that incident report would also include information about the victim in that case, which may be the shop owner. And so that incident report also gives us the means to be able to do proactive reach outs and provide any letter of support or any level of support or victim services to the victim that may exist in that case. And so there's just reasons operationally why we want to make sure we can get that straight from the source. So this data we're talking about is less of I would say not concerns here about the data quality issues, but it's really about making sure more than anything that legal mechanism for us to continue sharing this interagency information is restored for the purpose of, being able to better serve our young people and their families.
Mm-hmm. And I'm inclined along the lines with Senator McCray with the release, very cautious about the release of any data that can be linked to other data. Is MONSE considered what type of agency is it considered a law enforcement agency? Is it, because we allow law enforcement, but I'd like us and the public to better understand where the authority or where might we find the authority to have this type of information if it wasn't for us passing the law, this exception.
Sure. So I think first it's really important to mention the portion of this law and statute that prohibits the disclosure of this information to be shared with anyone. It's being provided very explicitly for the express purpose of informing the development of that comprehensive treatment plan. It cannot be shared with other people. We cannot use it for other purposes. And so that's very important, I think, to start with.
Mm-hmm. Well, in that case, could the information, so usually if you're going to in a social work or a social service context, there is an interview with the client. Could this information be gathered directly from the client or their family?
So we will be meeting with the client and their family. I guess the question is, do we want to, if we have interagency partners who are willing to share the information, we would be putting the onus on that young person and family to have the documentation provided. I think in some cases, the young person and family may have it, but I don't know. And so we're in the process with BPD and DJS of working on an MOU that makes very clear sort of where each party's responsibility stands. I think, Senator, just to go back to the first question you asked, we are a non-law enforcement agency. We're also a mayoral office. And so we already have a practice. I mentioned the group violence reduction strategy. That partnership relies on close communication, coordination, and data sharing in ways that are confidential, but allow us to have real-time information and the ability to intervene with the people who are at the highest likelihood for involvement in gun violence. That partnership's been so effective because we have found a way to share that information and have a process that works. We want to make sure we can do the same thing and take those lessons learned when it comes to our young people. And of course, when we're talking about our young people, it's very important that that information is protected as tightly as it is. We're here to make sure that we can put in place comprehensive programming when young people are referred to us that stop them from coming back into the system, weeks, months, years later at higher and increasingly severe levels of offense. We want to make sure that we're reducing that kind of recidivism that we see.
Got
So,
that. Okay,
yeah.
that's great. Senator Hayes, and that he'll be, I think, the last question on this bill.
Thank you, Madam Chair. I just wanted to reinforce two things. One, is it true that the original authority was provided to the criminal justice coordinating
Mayor's
system?
Office of it was Mayor's Office of Criminal Justice, which of course was the agency that Monty replaced and rescoped.
Got you, but it wasn't the Criminal Justice Coordinating Council.
Not in this statute, no.
Got you. It was the mayor's office. Got you. Thank you for that clarification.
Oh,
The
absolutely.
second thing, Senator McCray brought this up earlier, but what and I'm sorry if I missed and you already responded to this. If you guys are accessing juvenile records, is there an opportunity? Do you have to first have the permission of the parent of that individual prior to accessing those juvenile records?
So that's a good question. I would say in most cases, yes, because we would not even be working with that young person if we don't have that young person and their parent showing up to an intake meeting. So if there's no follow through, let's say DJS has an intention of referring a young person to us, but we can't get any cooperation or contact with the parent, we're not going to be able to move forward with that case. So those are
Right.
not records that we're accessing. So I think in most cases, I would say yes. We're
Gotcha.
still
But I'm
figuring
not,
it out.
and I just want to make sure you understand what I'm saying, Stephanie. I'm not saying that any other agency, so whether it's DJS, departments, whatever. The question is, when Muncie is accessing young people cases, does the parent give express authorization to Muncie to access their records? Or is the reason why you're a little fuzzy because the permission may have been given to another partner agency?
Well, so let me be clear about, I guess, a couple things. So right now, I mentioned the MOU with BPD and DJS. We don't actively have programming where we're receiving those referrals from BPD and DJS. We're working to make sure we have the foundation in place, the MOU in place, so that we can start accepting those referrals. When that process starts, DJS is going to have a young person. They may be eligible for that diversion. They're going to conduct their intake conference and do everything that they would do at the front end of a case that comes to them. But if that case is eligible for diversion, what DJS will be able to do is let that young person and their family know, hey, we're going to give you an opportunity for this diversion. Do you want to accept it? And there will be a consent process at DJS. That's how we'll be able to get that referral and then transfer. So it's going to happen because we're the recipient of the referrals. I think the reason I'm fuzzy is because the other agencies are playing a role in that initial decision to divert and then also working on the front end with the young person and their family to see if that's the right option for them. And then where it is, we're of course then in that transfer conducting our own intake process with that young person and their family, getting those signatures again before we start to do the work with that young person. So I don't know if that helps clarify the process and kind of where we are right now, but I'm also happy because we're still in the design process to share some of this feedback and see how we can make sure it's explicit. Because I think what I'm hearing you say is that it would be important for that parent, that family to understand that these records are being disclosed explicitly to Monty as a part of whatever diversion or service
or we could add
provision.
it as an amendment to the legislation to make sure that that happened as well. I don't want to occupy too much time because we do have a full agenda,
Yeah.
but if you guys could backtrack, because I probably
We'll
have some
follow
more
up.
questions prior to us
Yep.
voting, I greatly appreciate it.
Thank you. Senator Ferguson and then McCray.
Thank you, Madam Chair, and thank you, members of the committee. Thank you, Stephanie. The bill references a comprehensive treatment plan in several locations, and it's the development of is comprehensive treatment plan. I know that there is the DJS version of one. Is this the legal term, or is this a legally relevant term, or is this just a office defined provision of services?
So this is the same language that existed in the prior carve out. The way I interpret it, at least in our case, I guess the language we use internally is sort of like that individualized development plan for that young person. That's sort of how I hear it worded within our shop. But I don't know, Jeff, if there's any legal relevance on your side to that language of development of a comprehensive treatment plan.
I don't think that term is further defined. It would be part of this sort of services and scope that your office is providing.
Okay, it's just a broad. If it is not legally defined, it just is rather broad. The development of a treatment plan, if not outlined as a specific thing, feels rather open-ended, and so it just jumped out at me. Maybe something that could be potentially tightened just to say there's certain criteria at which these records are released. That and I guess the disposal of the records is the other thing that I was going to ask about, whether or not there's retention policies of disposing of the record at some point if there is a request by the juvenile or the young person or their parent, guardian.
So there definitely are disposal responsibilities of the records. Jeff, you may know better than me in this moment. I want to say it's 5 years. After 5 years of access, they have to be destroyed, essentially. And again, they can't be furnished to any other party. They're only being provided for that explicit use. So this would be governed by the same exact
Standards as others.
policies that are in here in the statute for all juvenile records.
Yeah, that's right. It would be in accordance with Monzi's approved sort of record retention policy. I think that would be, as you said, probably the 5 years. And just to reiterate, I mean, there are a lot of IT security systems in place, and the law department works closely with Monzi, just to ensure that any protected info is not released or disclosed improperly. And to point out again, this carve out, as in the past, does place strict liability on Monzi and the city if any information is improperly disclosed. So that's certainly something we take seriously.
Thank you.
Senator McCray.
Thank you, Madam Chair. And Madam Director, I'm not sure if you heard me when I first, like I said, I see the intent. But I just wanted to be clear in reference to my position. I do think that express permission, as Senator Hayes had spoke about, with the adult, whoever the guardian is, in that respective relationship is very important. My concern is I don't believe that I've ever voted on something like this, but who piles on? So I would be setting a precedent. And I think that when the document is signed, it should also name the 3 respective groups or organizations that you have stated that would have some level of permission. I also think, Madam Chair, that we should have some level of a sunset so that this does come back before us, whether it's 3 years or 5 years, to continue to keep monitoring this because it is sensitive information. I get the reason why they're doing it and how helpful it is doing it, but I'm very protective of young people and just the information to share, and the adults in the relationship are clear in reference to what's happening with that information.
Well, and thank you, Senator McCray. And we absolutely cannot be under concerned about access to that data by other sources. Cybersecurity threats are quite real, and we wouldn't want any of this information in
Well,
the
I
wrong
just
hands.
mean like other agencies. So
No,
other
I know what
agencies
you, I get
may say,
you.
hey, you guys gave it to this respective organization. Why can't I access that?
Mm.
And the parent may say, hey, no, I don't want that respective group to have this information, but I am okay with this one. But like, it's almost like a paycheck. Any type of deduction that comes out of your check, you know about before you have that deduction.
And McCray, on that point, I agree with you entirely. I was just expanding to the broader implication that somehow Monty could protect the data in a way that has not been able to be protected in other contexts. Any other questions or concerns on this? Okay, thank you all so much. That's the end of the bill hearing on Senate Bill 524. Let's hear from Senate Bill, this is by request also, Senate Bill 636, alcoholic beverages. The witness here is Michelle Wurzberger. She's a Deputy Executive Secretary for our Board of License and Commissioners. And then we will get to the alcohol bills quickly.
I will go quickly. Good morning, everyone. Thank you for allowing me to be here today. Senator, thank you for introducing the bill. This bill seeks to make two technical changes in the law that will hopefully reduce unnecessary administrative burdens on our licensees. The first change deals with Class A licenses, and you all know that those licenses are 6-day licenses. Those individuals can sell alcohol Monday through Saturday. But the law allows them to get what we call a special Sunday license between Thanksgiving and New Year's, where they can sell alcohol on Sundays between 1 p.m. and 9 p.m. They pay $120 for that license. And a lot of our licensees take advantage of that. The problem here is that the law requires that they apply for those licenses by September 30th. It's an arbitrary date. It doesn't impact us in our ability to do our job, but might limit licensees' ability to acquire one of those licenses or several of those licenses because they're just not paying attention during that time period. So that's the first change that we're seeking. The second one deals with personal property tax. And as you know, licenses have to be renewed annually every single year. So by March 31st, licensees have to apply for their renewed license. They have to satisfy their state alcohol taxes. If they don't, then the state comptroller will send us a hold, and we are not allowed to release the license until that hold is satisfied. Either they pay their full tax liability or they develop a payment plan. Now, in addition to that particular kind of process, which is huge, and we're right smack dab in the middle of it right now, in October, we are required to assess whether or not licensees have satisfied their personal property taxes. And if they haven't, we're supposed to immediately close them down without hearing, without anything. That October 30th deadline is, again, also arbitrary. Personal property taxes are very different from regular, state taxes or federal taxes, where everybody's got to get their tax return in by, I think it's April 15th. For personal property tax, those liabilities, those assessments are issued on a rolling basis. So no one has to pay at the same exact time. And so what we're trying to do here is move that deadline, not get rid of it. Because the licensees need to take care of those liabilities, but make it so that it is in line with the renewal process, where everyone's already focused on addressing all of their kind of outstanding business items. And there is another technical, there's one small technical amendment when I prepared the language and sent it off. I asked for the requirement be that they address it by March 30th. I forgot that there were 31 days in March. And so the technical amendment, it moves it to, changes the deadline to March 31st. So you should have a copy of my written testimony. I'll pause there because I know I went really quickly to see if there's questions.
That's great. Are there any questions on this bill? All right. Well, thank you very much. Senator Hayes, I know that this today is alcohol day, so I want to make sure, see if it's any possible, if we're able to get through those bills that are going to be heard today. So I guess next we'll go to 642, Senator Ferguson, and then I believe Senator Hayes, you have a bill that's going to be heard, and then I'd like to, if there's unreadiness with any of the bills, that we could vote for the alcohol bills today. So go ahead, Senator Ferguson.
Thank you, Madam Chair. This is the sort of annual 46th District alcohol licensing issues that arose in the district. So there are 3 provisions in this year's bill, and I would say 2 out of the 3 of them are related to the good senator from the 40th District. So the first is that the 40th District is losing, sorry to say, culinary architecture, which is a wonderful establishment. They were in Pigtown. They are now moving to the 46th District in Little Italy. So we are glad to welcome them, and the transfer would be within the prohibited areas close to a church. And so both of the Little Italy neighborhood associations have approved. And so we have, this would allow them to make that transfer possible from one district to the other. The second provision has to do with a certain fraternity that shall not be named, that it is hosting events for a large convention, which we are very thankful to have them in the city. And so this will allow for, there's an odd prohibition on donations of alcohol for events at the convention center, which is a surprising, generally surprising, but so this would allow for donations of alcohol by manufacturers and wholesalers for an event, for events at the Baltimore City Convention Center with a 2-year sunset that's included in there. And then finally, there is a transfer provision from Fells Point to a new venture in Harbor East that was a license that during COVID had gone dormant, and this would allow for the transfer to be the host of a new venture in Harbor East. So those are the 3 at the moment. We may, when it comes back to the cross-file, have some amendments for some things that have emerged, but at the moment we're not there.
Sure, great. Next, Senator Hayes, your bill, SB 927.
Yes, ma'am. Thank you, Madam Chair. 927. Oh, yes. This should look very familiar to you all. The very first bill that we dealt with as a delegation was a promoter's permit. There is another big conference coming to Baltimore in 2027 for the first time since 1968. And similar to CIAA, we want to just make sure that, we have a handle on, outside promoters that may be coming in town and others, and have the, and be able to mobilize all of our public safety resources and things of that nature. And so this bill is very similar, except the only difference is the change in the organization, and it's for related event promoters in downtown. It's really specific to the 2027 National Convention that we've been able to track here to Baltimore that has not been in Baltimore since 1968.
Okay, so thank you. Okay, any questions on that bill? That would be, okay, thank you for the bill hearing. And I apologize, I see on the calendar, there's Senator Tar, you have a bill for a license extension. Did we already hear that?
Yes, we did.
We did, okay, great.
Yeah.
All right,
Did
and
we,
we sent
did
the
we,
letter.
did we vote on it though?
We did, yes.
Yeah, I
So
thought
you have
so.
everything you need.
Yeah,
Yes.
yep,
Okay.
no, we're good. Look, we're on it. Okay, so I'm gonna ask, I'd like to just sort of vote them as a calendar, but if there's any unreadiness on any of them. So is there any unreadiness with,
Wait a minute.
oh,
Madam Chair, is Senator McCray still on?
I am.
Senator McCray, you had raised a question. I know about that first one, 636. Did you want to?
Well, that's
Or-
what I was, yeah, that's what I was
Yeah.
asking. Thank you, Senator Hayes. You're starting to chair the meeting even before I'm out
No,
of the
no,
seat.
he was on mute.
I'm
He was on mute.
aware.
So I wasn't sure if he knew.
That's
that
the term unreadiness. It gives people an opportunity to not object, but express unreadiness.
Madam Chair, I'll be honest with you. So like, I thought are you talking about the liquor bills or are you talking about all the bills that we heard?
No,
today?
just the liquor bills right now. So this would be the bill from the Board of Liquor License Commissioners, SB 636. So I'm just asking about that one, and then I'll ask about each one. So yeah. Okay. All right then. All right.
I don't have a problem.
Okay, cool.
Okay, great. And so therefore, if we could take as a calendar, Senate Bill, so Elijah just track this, Senate Bill 636, Senate Bill 642, and Senate Bill 927. Okay. Can I have a motion?
Move favorable on those three bills.
Second?
Second.
Okay. All in favor?
Aye.
Aye. Okay. I just need to do a time check-in with the Senate President. Are we okay, or because we have time, we can hear the other bills
Please.
Monday. Oops.
You're good.
Okay, great.
We don't go to the floor till 11, right?
Well, just checking. I thought there was something else going on. All right. So the next bill then would be, oh, sorry.
7:30.
Oh, that's me. Sorry. All righty. Good afternoon, colleagues. This is Senate Bill 732. It's the same bill that we passed, I think 2 years ago, and it is setting up, building off of the setting parameters, or continuing to set parameters for the use of cannabis funds. So we know that since the distribution began in 2023, the city has received more than 9.2 million in CRF funds. And that represents about 30% of all statewide funds. So what this does, this bill seeks to do, is to have the allocation of the monies go from comptroller to comptroller, and then also it directs the city for it to be distributed according to the same statutory requirements that govern all the other bills, funds. I believe that, the comptroller's office is an independently elected office, and it does have a fiduciary capacity. It's also an opportunity to ensure that our community-based organizations can have a direct line, and that there could be a very clear path for the allocation of the funds. If I could point your attention to just page 5 of the bill, it says that the comptroller shall establish a special account to be used only for holding funds allocated from the fund, deposit each quarterly allocation from the fund to a special account, distribute the allocations from the fund to be used only in accordance with this subtitle, which specifies uses specifically having to do with the over-incarceration of individuals. It can only be used for behavioral health, education and after-school programs, truancy and absenteeism, housing, transportation, job training, and workforce. This is in the existing law. Community childcare, any of those things that have found to be associated with communities where there has been a disproportionate a number of people both addicted, but also being incarcerated as a result of drugs. And it has other, not just Baltimore, but just statewide. None of the money can be expended for law enforcement. The fund is supplemental to and may not supplant funding that would otherwise be appropriated from pre-existing local government programs. And here the comptroller, again, is our state comptroller sends the deposits directly to the Baltimore City comptroller. And so it also says that no sort of separate funds could be created, no special fund other than is just specific to this. That's the bill. We'll be asking for your favorable report and any kind of discussion. And I think it would be good if Senator Hayes, if you could, I know that there was some questions about the bill and how it might introduce some flexibility for Baltimore City government to use. Could you sort of dispel or clarify that, if you would?
Yeah, sure, Madam Chair. I spoke with our committee analyst, and she feels pretty confident in the bill as drafted, what she drafted prevents that.
That's specifically what, if you don't mind?
That it does not allow local governments to siphon off portion of the funding.
Okay, all righty. Any questions on this bill? Okay, thank you. And again, this is in the posture that
Madam Chair, quick
yeah.
question.
Sure.
The 9.2 million, what has it been appropriated to thus far, like in the past years?
Well, we should ask city government. We know that one of the things I noticed this year that gave me a little pause is that roughly 5 million of the funds, so more than half of the funds that Baltimore City has received to date, was directed to an existing city agency with an established budget, rather than being distributed through the community-driven process that was set up by the commission that they set up. And I certainly understand pressures to use these types of funds. And again, this isn't just targeting Baltimore City. There's a statewide bill that addresses this as well. But we're being really clear about that it should not be supplanted in that way. So Senator, that's what I know now, but I don't know, and we've not gotten any reports. They're actually not required. Well, they're not required under the existing law, because we know a lot of organizations or local governments were still setting up their programs, but some reporting should be coming out soon, we hope. But we can certainly ask that question. I don't know if Nina can provide us if there's been any distribution of the funds other than the 5 million to an existing agency. And one of the other challenges is that in the current law, there's really no way to reassign that money. So we have to establish that authority as well.
So Madam Chair, Nina Themelis, again, apologies for not having camera on. So the city has not dispersed funds as of yet. The Office of Social Equity was tasked with providing jurisdictions with guidance, regulations for how those funds should be distributed. I believe at this point, we still do not have those regulations. And then just for the record, the funding that was transferred from the entirety of the fund over to the Office of Equity and Civil Rights, based upon our local legislation, the Office of Equity and Civil Rights is responsible for disbursement of the fund based upon the recommendations set forth by the local commission that we have. So no monies have actually been expended at this point, even from that 5 million. It was allocated in advance for fiscal 26 in order to provide for that funding to be available to be dispersed once that guidance was received from the Office of Social Equity.
Well, we can talk more about this, but again, my reading is that that type of distribution within a existing organization is sort of outside of the law. So this will clarify it going forward, and it will just be very clear that there'll be a separate fund, and then the entity that was set up to direct the funds will direct the funds. I'm not if you look at the state law, there's no reference to allowing for the city government or local government to create an agency to be in charge of it. It's very clear that this is to be a community-driven advising role. So this should clarify everything going forward. Any other questions or comments? And perhaps, we could perhaps get a briefing about what's going on with the opioid funds and also the youth fund. I understand there's some news about that as well. Okay, so that's the end of that hearing for SB 732. Let's get back to my agenda. Where are we? Okay, that's it. Any questions, any comments, any other information people want to share? Okay, great. So we'll meet this coming Monday, and we have some other bills to hear. And then I'd like people to have a chance to kind of look at any other bills, and we'll have a voting session. I'll take a motion to adjourn. Oh, okay, good. There we go.
Wait a
I
minute,
have a
hold
question. All right, what do we need?
on. We have another bill.
Okay, which one? Oh,
SB
yes, we do.
554.
That's it, Senate Bill. I circled it as, okay, Senate Bill 554. Yes, please, that's important.
Yes. Thank you, Madam Chair. This is a really, I'll be really quick and open up for any questions. This is an attempt to modernize our current way of appointing members of the Baltimore City School Board. Years and years ago, my predecessor took a courageous step in establishing the city-state partnership. And it's which we currently have in our school board. Baltimore City, like many school boards throughout the state, have 2 appointed members, but the remaining members are appointed by the mayor after a group of 13 special interest groups submit a list to him. This simply streamlined that process, giving the mayor the authority to appoint school board members, but it also add a level of transparency. Right now, there's no mandated public process in which members are aired, and so we're looking at the confirmation process that's established in the Maryland State Senate as that public opportunity where people get a chance to chime in. So it's an opportunity to modernize their appointment system as it relates to the school board, giving the mayor the ability to appoint absent the panel of 13 groups, and then confirmation by the Maryland State Senate.
Okay. Any questions? I thought perhaps the school board. So just, what is the school board of commissioners' position on this? Have you heard anything from them, Senator Hayes, or?
No, I know that they're aware of it. And their lobbyist or government relations person has the information, but I don't know if they've taken an official position on it yet.
Great, thank you. Okay, well, that's that hearing. Now we've heard all of our bills. We are now we can talk about next week. Speaking of the school board, I know we're looking for an opportunity to get a briefing on the process, how we're going forward on looking for a new superintendent. So I know members would be interested in that. We also will be getting the briefing with the sheriff's office in the upcoming days. Any other information for the good of the group? Yes, of course, Senator Hayes. Yes.
The only thing that I want to share with my colleagues, this next week starts CIAA week. There's going to be a lot of activity in Baltimore. There's opportunities through Visit Baltimore. If you want to sponsor a group of kids in your community or your local rec center, they are encouraging folks to do so. To have young people have an opportunity to attend one of these collegiate games where you have 13 historically Black colleges and universities is just, phenomenal that we're able to host this here in the city. And so I would encourage people to go to Visit Baltimore's page with a list of all of the activities that's happening throughout the week, including tomorrow. We will be in a 46th district launching the Black owned restaurant tour at Bar Vegan. And so looking forward to a week full of fun and activity in the great city of Baltimore through CIAA.
Okay. All righty. Thank you. That definitely is for the good of the group. All right. Can I get a motion to adjourn?
Despite the 40th district continuing to encroach into the 46th district, I'd motion to adjourn.
All right. A second.
Thank you. Second.
All those in favor say aye.
Aye.
Thank you all so much for an enjoyable and informative and productive session. Look forward to seeing you all on the floor. And thank you to the community for watching and participating. And we look forward to seeing you next week.